If you're 65 or older and you've seen headlines recently about new citizenship rule changes targeting seniors, or if someone sent you a message that made your heart sink, or if you've been lying awake at night wondering whether your status is suddenly at risk after all these years, I need you to stay with me for the next few minutes because what I'm about to share could be the difference between unnecessary panic and actual peace of mind. Over the past 2 weeks, my inbox has been flooded with messages from seniors asking the same questions. Is my citizenship being reviewed? Are they changing the rules for people over 65? Did I miss something important? Am I about to lose everything I've worked decades to build? And I want to say this clearly right at the beginning so you can take a breath. Your citizenship is not being taken away. There has been no law passed that targets seniors. There has been no executive order that puts older naturalized citizens under automatic review. What has happened is that procedural guidance was updated, online headlines distorted what that actually means, and suddenly thousands of seniors are terrified about something that doesn't affect them the way they think it does. In this video, I'm going to do something very specific. I'm going to show you exactly what changed, what did not change, who this actually affects, and most importantly, what's real versus what's completely fake in all the rumors flying around right now. I'll also give you the exact questions you should be asking if you're applying for citizenship, and I'll show you the red flags that mean someone is trying to scare you for clicks rather than inform you with facts. But before we go any further, let me explain why this particular topic has caused so much fear, because understanding that will help you spot misinformation in the future. Immigration news doesn't feel like regular news when you're a senior who spent 30, 40, even 50 years building a life in this country. It doesn't feel abstract or distant. It feels personal. It touches your identity, your home, your family, your right to be here. When you see words like rule change or citizenship review, your mind doesn't think about paperwork adjustments. It jumps immediately to worst-case scenarios. Am I going to be questioned? Will they make me leave? Did I do something wrong without knowing it? That reaction isn't irrational. It's deeply human. And here's what makes it worse. Social media and YouTube algorithms reward fear, not accuracy. A video titled "Breaking New Senior Citizenship Rules" gets 50,000 views. A video titled "Minor Procedural Clarification About Documentation Verification" gets 400 views. So creators, even well-meaning ones, use language that sounds urgent and dramatic because that's what gets attention. And suddenly you're seeing multiple videos and posts all using scary words, and it starts to feel like something massive happened overnight when legally, it didn't. I'm not here to judge those creators. I'm here to give you the truth in plain language so you can separate what's real from what's exaggerated or completely made up. So let's start with what actually changed. In late January 2026, U.S. Citizenship and Immigration Services issued updated guidance to officers who process naturalization applications. This guidance specifically addressed how officers should verify eligibility for senior accommodations during the citizenship process. Now, if you're not familiar, let me explain what senior accommodations are because this is critical to understanding the whole situation. For many years, the immigration system has recognized that age affects memory, language learning ability, and test-taking capacity. So if you are 65 years old or older and you have been a lawful permanent resident, meaning a green card holder, for at least 20 years, you qualify for modified testing. Specifically, you can take a simplified version of the civics test, and you can take it in your native language with an interpreter present instead of having to take it in English. These accommodations have existed for decades. They were created because the system recognized that expecting a 70-year-old who's been here for 25 years to memorize 100 civics questions in English might not be reasonable, especially when that person has contributed to this country for decades, paid taxes, raised families, and followed every rule. Now here's what the updated guidance said. Officers should carefully verify that an applicant actually qualifies for these accommodations by checking documentation that proves their age and the length of time they've held permanent resident status. That's it. That's the change. Not new restrictions, not new barriers, not a crackdown. a reminder to verify eligibility for accommodations that already exist. But when that guidance was summarized online, it got translated into headlines like New Citizenship Rules for Seniors, or USCIS targeting older applicants, or Major Change to Senior Naturalization. And those headlines, while technically referencing something real, created the impression that something punitive or dangerous was happening when the actual guidance was about procedural consistency. Now let's talk about what did not change, because this is where a lot of the fear is completely unfounded. First, if you are already a United States citizen, whether you were born here or you naturalized 5, 10, 20, 30 years ago, this guidance does not affect you at all. It does not reopen your case. It does not put you under review. It does not create new grounds to question your citizenship. Once you are a citizen, that status is permanent unless there was serious fraud involved in obtaining it, and even then, the government would have to prove that in federal court with evidence and due process. A procedural update about how new applications are processed has zero impact on people who already completed the process years ago. Second, the accommodations themselves have not been eliminated or made harder to get. If you are 65 or older and you have been a green card holder for 20 years or more, you still qualify for the simplified civics test and the option to test in your native language. That has not changed. What changed is that officers are being reminded to verify you actually meet those criteria before granting the accommodation. That's not a restriction. That's making sure the right people get the right benefits. Third, there has been no increase in the denial rate for senior applicants. I've spoken with immigration attorneys who handle naturalization cases every single day, and they have confirmed that approval rates for seniors who meet the eligibility requirements have not changed in any measurable way since this guidance was issued. The idea that suddenly seniors are being denied citizenship at higher rates is not supported by any data. It's speculation based on fear, not facts. And fourth, there has been no change to the legal standard for what constitutes fraud or misrepresentation on a citizenship application. Some rumors online have suggested that making a small mistake on your N-400 application could now result in denial or even deportation. That is false. The immigration system has always distinguished between innocent errors and intentional fraud. A typo, a forgotten middle name, an incorrect date that you wrote by accident. These are not fraud. Officers know that people make mistakes, especially when filling out complex government forms. In the vast majority of cases, if there's an error, the officer will ask you to clarify or provide additional documentation. You correct it, and the process continues. Fraud is when someone intentionally lies about their criminal history, hides a previous marriage, uses a fake identity, or provides false documents knowing they are false. That standard has not changed. It's always been serious, and it's always required proof of intent to deceive. A lot of fear right now is coming from people confusing these two very different things. Now let's talk about who this guidance actually affects, because this is important. If you are already a U.S. citizen, you are not affected. Period. If you are a green card holder who is not planning to apply for citizenship anytime soon, you are not affected. This guidance is specifically about the naturalization process, not about green card status. If you are under 65, this guidance about senior accommodations obviously does not apply to you. The only people who need to pay attention to this guidance are seniors who are currently in the process of applying for citizenship or who are planning to apply soon. And even for them, this is not bad news. It's simply a reminder that when you apply, you should make sure your documents clearly show your date of birth and the date you became a permanent resident, so the officer can easily verify that you qualify for accommodations. That's preparation, not panic. Let me give you a concrete example of how this works in practice. Say you are 67 years old and you received your green card in 2001, which means you've been a permanent resident for about 25 years. You decide to apply for citizenship. You fill out Form N-400. During your interview, the officer looks at your application and sees you requested the English language exemption and the simplified civics test. Under the updated guidance, the officer will verify that you are indeed 65 or older by looking at your birth certificate or passport. And they will verify that you've been a permanent resident for at least 20 years by looking at your green card and possibly your immigration file. If everything checks out, which it should if you actually meet the criteria, the officer approves your use of those accommodations, and your interview proceeds with the simplified test in your native language. Nothing scary happened. Nothing got harder. The officer just followed a checklist to confirm eligibility. That's the reality. But online, this same scenario gets described as USCIS is now scrutinizing senior applications, or they're questioning whether you really qualify. That language makes it sound threatening when it's actually just standard verification. This is why I want you to be very careful about where you get your information, because the same factual situation can be presented in two completely different ways, depending on whether the person talking to you wants to inform you or scare you. Now I want to address the single biggest rumor that has been circulating, and this one has caused more panic than anything else. The rumor is that the government is planning to denaturalize seniors, meaning take away citizenship from older immigrants who naturalized years ago. This rumor is completely false, and I need to explain why so you can stop worrying about it. Denaturalization is a legal process that exists, but it is extraordinarily rare and has nothing to do with procedural updates about new applications. Denaturalization happens when the federal government files a lawsuit in federal court arguing that someone obtained citizenship through fraud or by concealing involvement in serious crimes like terrorism or war crimes. It requires a judge, a trial, evidence, and the opportunity for the person to defend themselves with an attorney. It does not happen administratively. It does not happen quietly. It does not happen because of small mistakes or because you're a certain age. And it certainly does not happen because USCIS issued guidance about verifying eligibility for test accommodations. The legal threshold for denaturalization is extremely high. The government has to prove that you intentionally lied about something material to your eligibility at the time you applied for citizenship. For example, if you said you had never been arrested, but you actually had multiple felony convictions that you deliberately hid, that could potentially be grounds for denaturalization. But even then, the government has to prove you knew you were lying and that the lie was significant enough that it would have affected the decision to grant you citizenship. The idea that a 72-year-old who became a citizen in 2010 and has lived here peacefully ever since is suddenly going to have their citizenship taken away because USCIS updated guidance about accommodations in 2026 is not based in reality. It's based on fear, speculation, and a fundamental misunderstanding of how the legal system works. If you are a U.S. citizen and you obtained your citizenship legitimately, which the vast majority of people did, you are not at risk. Your citizenship is not fragile. Your status is not being reviewed. You can breathe. Now let's talk about what you should actually do depending on your situation, because action based on facts is always better than paralysis based on fear. If you are already a U.S. citizen, the action is simple. Nothing. You don't need to do anything. You don't need to hire a lawyer to review your case. You don't need to request your immigration file. You don't need to worry that something you wrote on your N-400 form 10 years ago is suddenly going to be a problem. Your citizenship is secure. If anything, keep your naturalization certificate in a safe place, and if you haven't already, consider getting a U.S. passport if you don't have one, simply because it's a convenient form of ID and proof of citizenship. But those are routine things you would do anyway, not emergency responses to some new threat. If you are a green card holder and you're not planning to apply for citizenship right now, again, you don't need to do anything differently. This guidance is about naturalization applications, not about maintaining your green card status. Continue following the rules you've always followed. Don't take trips outside the U.S. that are longer than 6 months without planning properly. Keep your address updated with USCIS. File your taxes. Live your life. Your green card status has not been affected by any of this. However, if you are a green card holder and you are planning to apply for citizenship soon, here's what you should do. First, make sure you have clear documentation of your date of birth. This usually means a birth certificate, a passport, or some other official government document that shows when you were born. If you're applying for senior accommodations, the officer needs to verify you are 65 or older. and having that document ready makes the process smooth. Second, gather documentation that shows when you became a permanent resident. Your green card has the date on it, but sometimes the print fades over the years, or the card has been replaced, and the replacement card shows a different date. If that's the case, request a copy of your immigration file from USCIS before you apply. That file will have the original record of when you adjusted status or entered the U.S. as a permanent resident. Having that documentation ready means the officer doesn't have to dig for it during your interview, which speeds everything up. Third, if you've traveled outside the U.S. frequently or for extended periods, gather records of those trips. If you spent several months in another country, have documentation that shows you maintained your permanent residence in the U.S. during that time. This could be lease agreements, utility bills, tax returns, employment records, anything that demonstrates the U.S. remained your primary home. This is not new. Officers have always asked about travel history, but having the documentation organized ahead of time makes your case stronger and clearer. Fourth, if English is not your first language and you plan to request accommodations, understand exactly what you're eligible for. If you are 65 or older and have been a permanent resident for 20 years or more, you qualify for the simplified civics test in your native language. If you are 50 or older and have been a permanent resident for 20 years, or if you are 55 or older and have been a permanent resident for 15 years, you qualify for the English language exemption, meaning you can take the test in your native language, but you still take the full civics test, not the simplified version. Knowing which category you fall into and being able to explain it clearly during your interview shows the officer that you understand the process. And fifth, if your case has any complexity, maybe you've been arrested in the past, or you've had immigration violations years ago, or you've been divorced multiple times, or you have a complicated travel history, consult with an immigration attorney before you file. A good attorney can review your situation, advise you on potential issues, and help you present your case in the strongest possible way. This is not a sign that something is wrong. It's being smart. Attorneys exist to help people navigate complex systems, and naturalization is one of those systems. Paying for a consultation now can save you months of delays or denials later. Now let's talk about how to spot fake information and misinformation about immigration, because this skill will serve you far beyond just this one situation. Here are the red flags to watch for. First, any headline or video that uses all caps and multiple exclamation points is prioritizing your emotional reaction over your understanding. Words like breaking, urgent, shocking, final warning. These are designed to trigger fear and get you to click, not to inform you calmly. That doesn't mean the information is always wrong, but it does mean the creator is using emotional manipulation tactics, and you should verify what they're saying from other sources. Second, if someone talks about new rules or major changes but never shows you the actual document, the actual law, the actual USCIS memo, be skeptical. Real immigration updates come from government sources. They are public. They can be linked to. They have official names and dates. If someone is telling you about a terrifying new policy but can't or won't show you where it's written, that's a red flag. Third, watch out for vague language like sources say or reports suggest or immigration officers are quietly being told. These phrases sound like insider information, but they're often speculation dressed up as fact. Real journalism and real legal analysis cite specific sources. If someone won't tell you where their information came from, you have no way to verify it. Fourth, be very cautious of any content that says this affects everyone, or no one is safe, or they're coming for all green card holders. Immigration law is extremely specific. Different rules apply to different visa categories, different time periods, different situations. Anytime someone makes sweeping statements that apply to millions of people without explaining the specific categories and criteria, they're oversimplifying to the point of misinformation. And fifth, if someone is trying to sell you something, whether it's a consultation, a course, a document service, or even just their channel membership, and they're using fear to do it, be very careful. Legitimate immigration attorneys and educators will explain your options and offer their services, but they won't terrorize you into buying. If the message is "you're in danger and I'm the only one who can save you," that's a sales tactic, not professional advice. So where should you actually get your information? Start with official government sources. USCIS.gov is the official website of U.S. Citizenship and Immigration Services. Any real policy change, any new form, any updated guidance will be posted there. You can read it yourself in the original language without anyone's interpretation or spin. Second, if you need help understanding what the official information means, consult a licensed immigration attorney or a DOJ-accredited representative working with a reputable nonprofit organization. These are people who have legal training, who are bound by professional ethics rules, and who have a responsibility to give you accurate advice. You can find attorneys through the American Immigration Lawyers Association website, and you can find accredited representatives through organizations like Catholic Charities, Lutheran Immigration and Refugee Service, or local immigrant resource centers. Third, if you consume immigration content on YouTube or social media, follow creators who cite their sources, who link to official documents, who explain things calmly without hysteria, and who have a track record of accuracy. You can usually tell within the first minute of a video whether someone is trying to inform you or scare you. Trust your instincts. If something feels manipulative, it probably is. Now, I want to speak directly to those of you who've been lying awake at night worrying about this. You are not alone in feeling afraid. Thousands of seniors have contacted me with the same fears. But I need you to hear this. Your decades of contribution to this country matter. Your years of following the rules matter. Your life here is not hanging by a thread. The immigration system, for all its flaws and complexity, does not casually strip people of status they've held for years. It doesn't work that way legally, and it doesn't work that way practically. What has happened here is that routine procedural guidance got filtered through social media and turned into something it's not. You are not in danger. You are not being targeted. The rules have not fundamentally changed. What changed is how clearly officers are being told to verify eligibility for accommodations that help seniors, and that verification process is meant to protect those accommodations, not eliminate them. If you've been putting off applying for citizenship because you're afraid, don't let misinformation steal that opportunity from you. Citizenship provides security, voting rights, the ability to petition for family members, and peace of mind. If you meet the eligibility requirements, if you've been a permanent resident for at least 5 years or 3 years, if married to a U.S. citizen, if you've maintained continuous residence and physical presence, if you're a person of good moral character, then you have every right to apply. Yes, the process requires preparation. Yes, you should have your documents organized. Yes, you should understand what you're eligible for. But none of that is new, and none of that should scare you away from pursuing something you've earned. Let me give you a final perspective that I think is important. The immigration system is massive. USCIS processes millions of applications every year. Within that system, there are constant updates, clarifications, memo revisions, training adjustments, and procedural tweaks. Most of these updates are boring and administrative. They're about making sure officers apply the rules consistently, that similar cases get similar outcomes, that documentation is verified properly. This particular update about senior accommodations falls into that category. It's administrative housekeeping. But because immigration is such an emotional topic, and because content creators know that fear gets attention, these routine updates get amplified and distorted into something much scarier than they actually are. Your job as a consumer of information is to step back, take a breath, and ask yourself, is this person showing me facts or triggering my emotions? Are they citing sources or making vague claims? Are they helping me understand, or are they trying to scare me into clicking, subscribing, or buying something? Those questions will protect you far more than any single piece of immigration advice ever could. So let's bring this all together with clarity. What's real? USCIS issued updated guidance about verifying eligibility for senior accommodations during naturalization. Officers are being reminded to check that applicants actually meet the age and permanent residency length requirements. The accommodations themselves, the simplified test and native language option, still exist and are still available to those who qualify. What's fake? The idea that seniors are being targeted. The idea that citizenship is being taken away from people who already have it. The idea that making small mistakes on your application will result in denial or deportation. The idea that there's some massive crackdown happening. These are distortions, exaggerations, and in some cases, complete fabrications designed to generate fear and attention. Who's affected? Current and future naturalization applicants who want to use senior accommodations need to ensure they have documentation proving their eligibility. That's it. Citizens are not affected. Green card holders not applying for citizenship are not affected. People under 65 are not affected by the senior accommodation guidance. What should you do? If you're a citizen, nothing, you're secure. If you're a green card holder not applying yet, continue following the rules you always have. If you're planning to apply for citizenship, organize your documents, understand your eligibility, and if your case is complex, consult an attorney. And most importantly, be critical of the information you consume. Check sources, watch for emotional manipulation, and prioritize facts over fear. You've worked too hard and contributed too much to let misinformation rob you of your peace of mind. The truth is less dramatic than the headlines, but it's also far less frightening. You are okay. Your status is secure. The system has not turned against you. And now you know how to separate what's real from what's fake the next time immigration rumors start spreading. If this video helped you understand what's actually happening and gave you some peace of mind, please share it with other seniors who might be worried right now. The antidote to misinformation is accurate information delivered calmly and clearly. Stay informed, stay grounded, and remember that you belong here. Your contributions over the decades have earned you that place, and no procedural update changes that fundamental truth.